a lecturer and, of course, a private legal practitioner himself, but lectures law too. Thank you very much for your time. Good morning to you.
Good morning, my brother. How are you doing?
I'm doing. I hope you are too.
Very well, thank you.
Great. A few terms have been thrown at us this morning. First, according to our understanding, they were in court, but only the applicants and his lawyers were in court because the other side had not been served. Why can't they proceed without the other side being heard?
All right. So thank you very much. Per the rules of the court, when somebody initiates or institutes an action, the rule says that the other party in contention must be served accordingly. And once there could not be a proof of service on the docket by the court, then the court would be barred from proceeding or going ahead with the case. That is why, if you look at one of the orders that was issued by the court said that if the applicant is unable to serve the defendant in this matter, they have to go through a substituted service. Substituted service simply means that the party that you are in court with cannot be found. And the law says that you must make 3 attempts. And out of those 3 attempts, it is just impracticable for the person to be served. Once that is established by the applicant, then the court will have that jurisdiction to give further orders to say that, well, if you cannot find him to serve him, which is his constitutional right, then resort to maybe WhatsApp service, you go paste whatever it is on his wall, that is his residence, or you go to maybe a place like the court where somebody might have seen the process and the defendant in this regard will be notified. So that is where we are currently.
I see. So that's how. So they are hoping that through using that process, he will be duly notified.
Absolutely. Because as it is right now, the court hands are tied. The court cannot proceed until they are able to, as it were, trigger that process, which is a substituted service that they ordered yesterday. So when they come to court in the next agenda date, which is the 13th day of January, the first thing the court will establish, if the defendant is not in court, is to establish through the applicant whether the defendant has been duly served through a substituted service. And once that is established, then you will see that the court, now the road will be clear for the court to proceed. Now, on the 13th, if the applicant is not able to go through the substituted service, and this is not just saying it, but they should be able to convince the court with pictures and messages to say that they have complied with the orders of a court, the court cannot proceed.
That's interesting, because I was going to ask whether even the substituted service mode has always worked.
Yes, it has. It has
a high chance of success.
Say again?
It has a high chance of success.
Yeah, it has. Because once, with a substituted service, all that the applicant needs to do is, first of all, per what I call the meaning gods of the law in Ghana, per what the meaning God said yesterday, the Supreme Court ordered that the defendant should be served through a WhatsApp message and then going to paste the process on the notice board of both the Kpandai High Court as well as the places that the defendant is likely to see. So all that the applicants need to do on the 13th day of January is exhibited in court. And my lords, we have complied accordingly with your orders through the substituted service, and these are the evidences or the proof of what we have done. And then the court will proceed. That is in an event where the defendant does not appear. Now, there are occasions where the substituted service will be done, but the discretion again of the court will be exercised. They will say that, well, you have tendered it, but the time of the the posting and then the serving through substituted service was late, and therefore try another hearing notice for the last time. But to say that as far as the validity of the substituted service is concerned, it has always worked, and that is always the last resort for the court when the defendant or the respondent cannot be found.
And in a wake of this, because of the explanation you've given, then what do you make of the court's decision to then suspend the rerun? Because they've set 13 January to hear the matter.
Yes. And that is in order. It is accurately right in law, because don't forget that the EC had given a notice that the rerun will be on the 30th of December. Now, in the reasoning of the Supreme Court, that 30th December is too close. Number one, for a service to be done on the defendant, and number two, when the service is done, they must come back to court to either reaffirm or the certiorari application to proceed. And in the reasoning or in the wisdom of the court, the 30th December will be too close for all those exercises to be undertaken. Hence, the date on the 13th day of January. Don't forget that the rerun is going to be in suspension until the declaration by the Supreme Court that now the road is clear, go ahead and conduct the election.
And was which for that, what is before the court is an application that they call a certiorari. What does that mean?
Okay, so a certiorari is a judicial review that an aggrieved party can seek for in the apex court. For example, one of the jurisdictions of the Supreme Court is the appellate jurisdiction. Appellate simply means they have a right that when procedure or when a judgment is delivered by a lower court, they have a jurisdiction to go into the matter and see whether the law has been duly followed. Now, if an aggrieved party feels that his right has not been respected, or he's of the opinion through his lawyers that he attended enough evidence in the matter for which it went against him, he has a right to go to the superior court, in this case the Supreme Court, and ask for a relief called certiorari. Certiorari simply means to quash down, or in the local parlance, to cancel a decision that was arrived or delivered by a lower court. So what the applicant is seeking to do, Honorable Matthew is seeking to do in this regard, is to say that the decision that was given or the judgment that was delivered by the High Court at Kpandai was erroneous, and he feels that the court did not have what it takes to do what it did, and therefore that decision to be quashed because he has all the evidence. So the Supreme Court now will go listen, hear the matter, and then give a ruling or judgment on it. So that's where we are currently. So certiorari is to quash or to cancel a previous judgment being delivered by a lower court or an administrative body.
And in this case, we understand it has to do with time, the time of the filing of the petition. And they think that it was filed out of time, and so the High Court did not have the jurisdiction to hear the matter. Explain to us how circumstances as such work.
All right. So the laws are clear that before one files a process, the rules of court is clear as how many days, how many weeks you have. For example, if one institutes an action in court, and you are served the process of the writ of summons, you have 8 days to enter into appearance, and after that you have 14 days to enter into defense. Now, once the door closes, it means that you cannot. And why, if you still intend to come, then you must come through a motion or an application for an extension of time which will allow you. Now, if you look at the instance case before the Supreme Court, they are playing on technicalities, whether 21 days had elapsed or whatever. But that is one of the issues that the Supreme Court would deal with. Now, the Supreme Court is robed with all the powers to look at the rules of the court and see whether there was that elapse of the 21-day period or it was within. And once the Supreme Court is satisfied, we will be able to see what the road will be. Now, because the matter is before the Supreme Court, all of us must shut up, because the Supreme Court is now officially and legally invited to preside over the matter. So we have to wait peacefully and listen to what the Supreme Court will say under the circumstances. Then we'll be able to reason either with them or disagree.
Well, thank you.